Diddy prosecutors caught accessing attorney-client privilege materials. That's a pretty big problem if that's true. Is this Diddy case going bye-bye? Maybe. Here is what the defense team submitted. Several different motions and letters to the judge asking for an evidentiary hearing because they've learned something bad. Here is what they sent in. Sent fresh out of the oven November 18th. It's a 3-pager. This is from Diddy's attorney, Agnifilo Intrader, says, defense counsel has recently learned that prosecutors are in possession of attorney-client privilege material, including Diddy's own written notes, meaning they went into the jail cell and stole it. This search and seizure are in violation of Mr. Combs' 4th, 5th, and 6th Amendment rights, and specifically illegal searches, due process, right against self-incrimination, and right to counsel, violating all of those constitutional rights. When you start to stack those into each other and apply those to a criminal case, those are big criminal constitutional amendments, big issues, okay, not minor things. Moreover, the targeted seizure of a pretrial detainee's work product and privilege materials, that's Diddy, he's in custody, that were created in preparation for trial is outrageous government conduct that amounts to a substantive due process violation. Dismiss, dismiss, dismiss. The violation is so bad, the sanction is you have to make this go bye-bye. Because the prosecutors are currently in possession of privileged material and are actively using this material to detain Diddy, the defense requests an immediate evidentiary hearing. This is an emergent matter because the government has Mr. Combs' Diddy's notes and their privilege notes to his lawyers concerning defense witnesses and defense strategies. They have our whole playbook. Now, the government's opposition to our bail motion, they want Diddy to get out. They've submitted, I think, a 3rd bail request. States that the trial prosecutors, they wrote, are currently in possession of possibly privileged materials such as notes recovered from the defendant's cell. So they admitted this. In fact, the government, they said, it's not possible. It is absolutely privileged. This is a matter of grave concern because most respectfully, it must be addressed immediately for the following reasons. First, there is no dispute that the government is in possession of privileged material. Second, until the government submission at 11:29 on Friday, November 15th, the defense had never been told that Mr. Combs' notes were taken from his cell, that these notes were given to the prosecutors, and that these notes were given to the trial prosecutors in this case, who then used this material to keep Combs detained in their filing. Wow. So essentially the government cracked the seal on this. The government admitted they might have something, and then the defense attorneys reverse engineered it and pieced together, yeah, they actually do have it. Then okay. So we request an immediate hearing at which the government shall provide answers to the following. First of all, who authorized a search of Diddy's sleeping area, his personal effects, and his paperwork? Where'd that come from? Second, who determined what paperwork to take of his? Third, who decided to give his paperwork to the prosecutor's office? And then once it got to the prosecutor's office, who gave it to the literal trial prosecutors in this case? And fifth, who made the decision to not tell Mr. Combs' lawyers that the attorney prosecutors were in possession of his notes, including, quote, possibly privileged materials, until after the government put them in a filing that they used to try to keep him incarcerated? And exactly what material was taken from his cell in the final note? Now, because the U.S. attorney, and it seems like the trial prosecutors, are currently in possession of privileged materials, we request a full evidentiary hearing as soon as the court can accommodate us. Signed, Diddy's lawyers. Wow. That's a problem for the government. So they've responded, and here's what they've said. They say the government submits this letter in response saying we don't need an evidentiary hearing, okay, it's unnecessary. They say on or about September 16th, as we know, Diddy was arrested. These are the prosecutors responding. We didn't do anything wrong. The following day, the above indictment was unsealed. The government moved to detain him, and he has been detained since. Now, since being ordered detained, Diddy has been at the MDC, a Bureau of Prisons facility called the Metro Detention Center, Brooklyn. With respect to inmate communications, all inmates, including Diddy, are afforded the opportunity to confer with attorneys on unmonitored phone lines. Other communications occur over monitored lines. As part of its practice to screen monitored communications for content that could jeopardize the safety of the facility, we monitor the communications on the monitored phone lines. This monitoring is independent of the U.S. Attorney's team. Okay, so the prisons are monitoring things for the prison's purposes, and if they catch something, they'll flag it and send it out. Now, as set out in our prior brief, during our previous bail hearings, we say that Diddy is continuing to obstruct this case. As part of our investigation, the government has sent grand jury subpoenas and documents, emails, and calls. From those materials, the government has learned that Diddy has persisted in engaging in obstructive conduct, even though he's in custody. He's engaged in unauthorized communication practices. He's doing three-way calls on monitored phone lines. So they're listening to that. He's using other inmates' phone access codes to make phone calls. They're monitoring those. He's using third-party text messaging providers through their monitored emails. Each of these methods is prohibited, and they're watching you. Furthermore, as set out in the government's notice, he's also using these to try to obstruct. He's trying to influence the jury pool, which is like a joke, okay? It's called defending yourself in the court of public opinion. He's allowed to have his whole family make their opinion known about this case. He's allowed to talk to them and have a conversation with them. The defendant has used all three of the aforementioned methods. It's called free speech. Accordingly, although it is clear to all parties involved that the emails are monitored, the government sent any potentially privileged communications to the filter team. So even though they're monitored, if it is about conversations about his case, we're still filtering it. As the government has a long-standing practice, like this one, the government did not disclose potentially privileged communications to defense counsel in the first instance. We've been doing this in covert investigations for a long time, so this is not even unusual. Now, we will ultimately produce all the materials today. Oh, so they got caught. Wow, they're so shady, these prosecutors. We have a long policy of not telling you when we have illegal material, and we're going to give you everything today. So there's no problem. We don't need an evidentiary hearing because you caught us, so we'll just give it to you. Scum. Now, they say in or around October 28th, there was a sweep of Diddy's facilities. The sweep was pre-planned and coordinated for safety. We weren't searching for anything. It included the jail and the warehouse where the food and other property are stored. It was planned in advance of Diddy's arrest. It was not conducted to target anybody. Now, although the sweep and multiple housing units were searched, including Diddy's, although members of the case team were aware that his housing would be searched, no one on the case team supervised or did anything in this. In fact, the case team who's prosecuting him was not even aware that they were doing this search. So Investigator 1 was assigned to the prison to participate in the sweep, whoever this person is. During the sweep of the housing unit, he interviewed multiple inmates, including Diddy, about potential corruption and contraband. Following his interview of Diddy, he approached Diddy's bunk and searched. On the bunk, Investigator 1 found the following items. This is Diddy's bed. A manila folder marked legal, a notebook labeled redacted, an address book, and personal effects. The investigator felt the outside of the manila folder marked legal for contraband, and feeling none, set it aside and did not open it or photograph it. With respect to the notebook labeled blank and the address book, he took photos of those materials. He left the materials on the bunk. No physical materials were seized. Okay, so he took photos of the photo of the notebook. We don't know what that said. Following the sweep, he then alerted the case team that he'd taken photos of defendant's blank notebook and address book called the photographs. He described the blank notebook as largely notes to self written by the defendant that included notes regarding this. In an abundance of caution, the case team asked Investigator 1 to provide the photographs to the filter team, given the possibility that they were legal. Uh-oh. Wait a minute, too late. Should have gone to the filter team first. Following review, the filter team provided certain photos to the case team, including photographs containing redactions. It's too late. Just to be clear how this went. Investigator 1, so we'll call him I1, sent it to the case team. Then the case team said, you can't do that. You have to send that to the filter team. So I1 then sent it to the filter team. And then the filter team said, oh, yeah, there's some problems here. And so they sent some materials back to the case team. Okay, but it was only like partial. So there were redacteds here. But the problem is they already got it here. They already saw it all. When they got it the first time, nothing was redacted. They saw it all. Oops. And then they sent it back. Too late. The government's brief mistakenly described the sweep as nationwide in their earlier brief. That was an error. It was only in D.C., in New York. For reference, the government is including other exhibits of the notebook labeled Things to Do. So there was another notebook called Things to Do, and the address book as Exhibit A, which contains redactions per the filter team review. This is a full set of material from the sweep. This exhibit is being filed under seal. Is that notebook? Did they just forget to redact that? Is that the notebook here? Labeled, is it Things to Do? With respect to the notebook labeled Things to Do, I don't know. Or it's a different notebook that they're okay not redacting. Because you can imagine there's legal stuff in a notebook entitled Things to Do. I wonder if that's a mistake. It says, on November 8th, the defendant submitted a renewed motion for bail in front of Your Honor. The government filed a response. They said that they actively see him continuing to obstruct things. They were also paying a potential witness and others, which had been provided to the filter team. More evidence. On November 18th, we then submitted another letter motion saying that some were privileged notes, and the defense requested a hearing, and that's where we're at now. They say, first of all, the photographs were entirely proper. They were taken during a normal sweep, nor is there anything improper about the photographs. They were entirely justified. He was inspecting these things. He's not even bound by the privilege doctrine. He took steps to respect the privilege. He did not examine the legal folder. He reviewed the materials in the notebook labeled something, and none of the steps were done at the case team's direction. They were not even aware of it at the time. Doesn't matter. The government did it. The government did it. They're all the government. Second, the government's use of a filter team is appropriate, and they segregated these things. Here, the photographs related to the government's ongoing covert grand jury investigation. They had no obligation to seek the defense counsel's view of this. And finally, the photographs are not privileged. None of this was prepared to obtain legal advice. They do not reflect the notes or the defense strategies, and so they're just not covered. Now, even if it was disclosed to the case team, which it was, even if there was a disclosure, as we just said there was, that alone is not a basis for this evidentiary hearing. The standard's much higher, and so we do not want an evidentiary hearing. We don't think it's appropriate under the law, and that's the government's response. Wow. So very shady behavior from those lawyers, those prosecutors. They got those materials. They knew about it. They made a boo in their prior filing. They got caught and called out on it. Then they disclosed everything that same day. They're like, it's not that big of a deal because even though we got it illegally, we then put it through a filter and then got it again. And we forgot what we saw the first time. Yeah. So huge mistake. And the Diddy team is capitalizing on it. Is the judge going to dismiss this case on this basis? He's probably going to want to know more about what is inside those materials. And so we'll keep our eye on this one. But he has to rule on it now. And the Diddy case is getting spicier and spicier. But this is good news for Diddy. They're always looking for arguments that give them big constitutional violations to latch onto. And they've got several of them here. So we'll see what the judge says, and we'll keep our eye on this one. All right.